Okay. Okay, so Heather, how does my executor gain access to my will, which is in my safe deposit box?
How,
just a second.
how the executor can get at the will that's in the safety deposit box? The short answer is, unless they're a signer on the box, they cannot get into the box. You need to have a safe deposit box that has either your executor or someone your executor can contact as an additional signer on the box. If you don't want another signer on the box, don't keep your original will in your safe deposit box. Keep it somewhere else where you might keep other important papers at home. It needs to be someplace that it can be accessed. We can go get court orders to get safe deposit boxes open, but what I was talking about before with probate being simple may not be true when you have to start getting court orders to get into safe deposit boxes and give banks notices and serve them and so forth. So yeah, make sure that you've got someone else as a signer on the box.
So my will is 10 years old. Can I send you updates by email? And can the bulk of my additional questions be answered by phone?
For second part of that question first, I do much of my business talking to clients on the telephone. Wills cannot be signed over the telephone, and email doesn't work. That said, when I have a client who sends me an email saying, I need to make these 3 changes to my will, I send them back and say, great, I can make those changes. You need to call and schedule a time to come and sign. It's useful to have the information ahead of time from the client by email, but it can work just as well if they call and schedule an appointment, and the first I hear about what the changes are is when we're sitting down to talk. It's quite easy to make changes when I was the one to have prepared your will in the first place. If you come with a will from another attorney, oftentimes we either have to start from scratch or we have to draft a codicil, which is the formal name for an amendment to your will.
Great. So I have no idea how to appoint an executor. Are there suggestions you can give me?
The only way you can appoint an executor is to have a will. A will will generally have one of the very first paragraphs in the will after this is who I am and I'm competent, and here's who my family is. There will be a paragraph that says, and this is who I want to be my executor. And if they can't, here's a backup. That is the only way you name an executor in your will. And if you need to make a change, you can't just cross out the name that you put in the original will and write in something new. That might end up invalidating the whole will, and that won't do anybody any good.
What's the process or cost of having a professional as your administrator or executor rather than a relative or friend?
It depends. Like any good attorney answer, it depends. Most of the time, a family member or a friend can be an executor and can do a perfectly good job of it, cheaper than a professional. But there are plenty of situations where there is not a reasonable choice, where there is not a trusted enough family member or friend. And then executors who do that for a living, there are several companies in the Seattle area, so from the very small kind of one-man or one-woman shows to large companies that have 35 or 40 employees who administer estates for folks who don't have anybody else that they can trust. And most of those companies are not going to charge based on the size of your estate. They're not going to charge based on how many months it takes to do it. They're going to charge how many hours it takes them to do it and what type of work is involved. When they have one of their employees preparing tax returns, that will be a different price than the person who comes to clean out the house and get it ready to go on the market. And they're going to have a schedule of their hourly rates for their various employees that you can ask them for when you're making your will, and that your beneficiaries can ask them for when they're administering the will.
So can you have an executor who is working from California and your will is in Washington State?
If they are named in the will, as long as they are a U.S. person, meaning that they're living in the United States as a tax-paying or legally reachable by United States courts, they can be anywhere in the U.S. It might not be the most efficient thing because they're going to have to sign papers that need to be presented to the Seattle courts. And these days, we can do lots by fax and email and scanning documents. But an executor can be anywhere. If you wrote them into your will and said you wanted them to do it, and they were ready, willing, and able to do it from California or from Arkansas or from North Carolina, they can administer your estate from anywhere. The only difference in administration is that they have to file, the attorney helps with this, they have to file what's called an appointment of resident agent, usually naming the attorney or some other trusted person in Washington who can be served if someone wants to sue the estate. Doesn't happen very often, but they have to have somebody local appointed to be that person, to be the local person who can be involved if there's going to be a lawsuit.
Can I just ask a question following that? What about someone who lives out of the United States as an executive?
When someone lives out of the United States, if they are a citizen, it is quite easy for them to continue to be your executor. If they are a non-citizen and they live outside the United States, it's not impossible, but it's a whole lot more complicated. And largely that comes down to tax reasons because the IRS doesn't already have jurisdiction over them. And so it's hard for us to administer the estate with the IRS.
How much do you have to leave a sibling to keep them from contesting the will?
I like that.
In some states, you have to leave certain relatives an inheritance. You have to leave them a minimum amount, and you can't completely disinherit them, whether that's a spouse or whether that's children or siblings or parents or nieces or nephews. Washington does not have any required amount that has to go to any beneficiary. You can disinherit your spouse. You can't give away their share of the community property, but you can give your share of the community property to anybody you want. You can disinherit children, and I'd say folks do that fairly frequently, from kids who don't need it to kids who they just aren't close with anymore and who have made their own way in the world. A sibling falls into the same category. You don't have to leave them anything. You can say, I care for them, they are my family, I nevertheless leave them no portion of my estate. You can say why, or you can say for reasons that they should be well aware, or you don't have to leave them anything. If they would inherit your estate in the absence of a will, they will be entitled to notification that your will is being administered, and they may want to challenge the fact that they're getting nothing. How much you have to give them to induce them not to challenge it really depends on the size of your estate. If you've got $1 million that they would inherit that they're not going to get, you probably have to give them more than $5,000 to induce them not to challenge the will if they think that there's really a bona fide basis to challenge the will. Challenging a will is not easy. You have to prove that the person wasn't competent, was coerced, didn't know what they were signing. You know, they thought they were signing a deed to the house and instead they were signing a will, or they thought they were signing a medical directive and it was a will instead. But short of that, wills are really hard to challenge. Anybody can challenge it. One of the things I draft into a will is a provision that says, if somebody challenges this will, not only do they get nothing, so that $5,000 you left them as an inducement not to challenge would go away. And you can say, and I direct that the court shall require them to pay all of the costs of this. Maybe that's enough to discourage them from fighting, and maybe it's not. At some point you do the best you can and hope for the best. And maybe you don't leave it as a surprise to them that they're getting nothing. Maybe you make sure some way or another you know that they know that I'm going to give my estate to the Y because I think they really need it and you really don't. And if they know and it's not a surprise, it usually goes over a little better.
Can you go back to just generally, what's the cost of doing a will?
So, because these prices are right on my website, I can tell you that it's a range. It depends. I do flat fees that start at $650 for the single person who has the simplest estate, and all the way up to about $3,500 for the married couple that has a very large estate where we're worried about IRS and Washington taxes, and where we have trusts and tax planning built into the will. So it depends, but it's usually fairly affordable, and I try and work with clients to make sure that we're getting the plan that's best for them and not based on what my fee schedule is.
So, and then here's some kind of specific stories to individuals that are here. So this person has one child and is divorced. Why do I need a will? Why do I need a will? I own my own house.
So, back to, I told you one of my stories about standing in court last week. I was in court about a year and a half ago, and there was a woman in line in front of me, talking to the judge, telling the judge that she was an only child, and she needed to administer her mom's estate, and there was no will. And the judge said, well, how can you prove you're an only child? Think about that one for a minute. I thought about it. I wasn't really able to come up with a way to prove that she would have, how can you prove that? You might be able to prove that you were somebody's sibling, but to prove that you didn't have any siblings is a tall order. Having a will makes it super clear. This is my child. I want them to get everything. It's not complicated to do, and if you do it with me, you're going to get those documents that help govern things while you're alive too, because your daughter has no right to make decisions for you, to handle your finances while you're alive if you don't have something written down.
Okay, so what happens if someone has a stroke, in this case the dad, and then a new will? Just a second. What happens if someone has a stroke? Let's read this.
Oh, if a will after a stroke can be valid, I think that's the question. And again, it depends. There are lots of, I have friends who are my age who have had strokes, who now you couldn't tell that they had anything wrong with them. There are also strokes that leave people quite debilitated physically, but not debilitated mentally. And there are strokes that leave people certainly unable to make a will. Every situation would be very, very much different, and it would require looking at the particular facts. If someone makes a will when they are not competent, those wills get challenged. And if there's a doctor's letter or a doctor report that can show that that person didn't have the capability of signing a will, that they wouldn't have known what they were signing, the will generally not be upheld.
Okay. So if a mother dies and leaves half of her estate to her kids, do they collect it before or after their dad passes?
That's an easy one. It depends. Usually the financial parts can be collected right away. If mom says, I give half of the estate to my kids, and she's got a bank account that only has her name on it, it's got dad's name on it already, he's gonna get it because he's the survivor on the account. But if she's got a bank account, that can go to the kids right away. If it's the house, unless the kids are going to file a lawsuit to make the house, force dad to sell his half of the house along with their half of the house, that will probably get delayed until dad dies. There's a way to make it easy and to set up a trust that makes it very clear that the assets are segregated. Mom's half goes into a pot that is a trust of mom's estate that can benefit dad while he is alive, but that it goes to the kids when dad dies. It's always better to have the plan spelled out than to sort of hope the kids and dad will get along when mom dies.
Does an ex-daughter-in-law have any claim to monies left to her children? Yeah.
So that touches on all sorts of things. In-laws don't generally have any claim whatsoever. Minors can't own things. So if money is left to children, their legal guardian, who might be an in-law, or some other person appointed by the court is going to be put in charge of their money. So the daughter-in-law, because she's the one caring for those children and has court responsibility to take care of them and their money, may very well have a say in their inheritance. And if you don't want that to happen, you set up a trust and put somebody different in charge of those grandkids' money.
Okay. Can you have an addendum to a will rather than have a new will? Have to write a new will?
Oftentimes I do that for clients. An addendum to a will is called a codicil. It has to have the exact same formality as the original will. Those two disinterested witnesses who watch it get signed and can attest to the capacity and lack of undue influence. But that oftentimes is a very good way to make small changes to a will. The problem with doing that is by the time you have 2 or 3 of those, it's kind of hard to keep track of which thing was being amended by which amendment, and cross-references to paragraph numbers that might change from one document to the next can be confusing. And the other thing is if somebody's getting disinherited because of that amendment, if there was a new will that just didn't give them anything, there's going to be a lot less hard feelings than if they see that they were in and then they're out. So you can absolutely do an amendment, but it's not always the best way to go.
Okay, good.
Oh, there's a question on that.
Oh, sure.
Yeah, on this subject, are not all of the codicils dated so that you have an exact chronological order of?
Absolutely, and it sometimes works out just fine and at other times creates confusion, particularly when it's an attempt to keep amending the same things over and over again. When the first codicil says, I take out paragraph that says give $5,000 to the church, and the next codicil says, that last amendment, I take it away, does that mean the church gets the $5,000 or does it not? And those are the confusing things. They have to be super clear in order to work. And by the time you get a lot of them, it just gets confusing.
Does a financial power of attorney have access to a checking account if he or she is not a joint owner?
Absolutely, and that is why we use powers of attorney and why I encourage people to have a power of attorney rather than naming a child on the bank account. The power of attorney, it gives the child or person named as agent the ability to handle all property, all financial accounts, digital assets nowadays, and all of the paperwork and financial affairs of someone's life. So having access to the checking account is oftentimes the big thing that it's for, but it affects everything. So.
Okay, so here's about bonds.
Uh-oh.
So I have bonds, and I have 2 bonds that are designated to one person. 3 bonds do not have beneficiaries. Can I designate in my will that the remaining bonds go to another person?
Yes.
Or have percentages go to that person?
Any assets that do not have named beneficiaries are going to be governed by your will. So having named beneficiaries takes them out of the control of the will. Having no named beneficiaries means that if you care in particular where that asset goes and don't want it just to go to your remainder beneficiaries, you need to address it in the will.
Okay, very good.
Can I, that's my question. These are nieces, so one niece has the beneficiary name, the other are the 3 bonds remaining, and they're worth less than what the other niece gets, so I'm trying to get it so it's 100%.
So that it's even Steven, huh?
Yeah, I don't want.
And that's why having beneficiaries named is oftentimes not the best way to make sure that your estate gets divided the way that you want it divided. If you say in the will, equal, then, and I oftentimes will draft into my wills for situations just like yours, a provision that says if one of my beneficiaries gets something outside of this will, that the assets that pass under the will can be used to, or should be used, to even it out, so that if one gets a $20,000 bond, that the other niece, if the will says equal, that the other niece might get $20,000 under the will before the rest of the estate gets divided. So there are easy ways to address that in your will.
Does a chair look at, sorry.
One more back.
Sorry.
Question. You have a joint will, and one of the spouses dies. In the joint will, you've made up a list of beneficiaries. How does one protect that list of beneficiaries when the second spouse dies?
So joint wills are a little bit of an, I would say, an older concept in Washington. I do not know of an attorney that prepares joint wills for couples anymore. We prepare a community property agreement that addresses survivorship between the spouses. If one of us dies, the other one gets everything. But that does not go on to name beneficiaries. When I sit with a couple and we prepare wills that look the same, they each have their own will. They're not joint wills. They each might have the same list of beneficiaries. And the short answer is if they give everything to each other, The survivor can change their will anytime they want to, say whatever they want. And if one half of the couple or both halves of the couple doesn't want that, there have to be some more complicated plans like a trust that might protect the beneficiaries.
Okay, does a charitable gift in your will or from a retirement account reduce the taxes on your total estate?
Yes. If you have a $3 million estate and you give $1 million to charity, only the $2 million that's left after the charitable gift is counted in determining whether your estate will be subject to tax or not. I use the $2 million amount because in Washington, estate taxes or estate tax return has to be filed as soon as the estate is over $2 million, but taxes are only paid on the amount that's over $2 million plus an inflation adjustment, which means right now it's $2,129,000. So, and that number changes each year, but the $2 million threshold, if the amount going to non-charities is under $2 million, no tax.
Back to,
There's another question.
okay, back to executors. Can you just say, if they're relatives, do they typically get money, and what's an appropriate level of compensation for executors?
Every executor, whether they are the sole beneficiary of the estate or whether they're just a friend or neighbor or professional who's getting nothing out of the estate, is entitled to be compensated for their services. Nobody is expected to do that job for free because it can be a lot of work. That said, if I'm the sole beneficiary of an estate, I'm not going to take a fee because any fee that I take for my services is income and subject to income tax. Where there's 2 or 3 beneficiaries of an estate, one of those beneficiaries serving as executor very often will not take a fee unless things get messy, unless there start to be fights, unless it turns out that getting that house ready for the market and dealing with creditors was a whole lot more trouble than they expected. I always tell my executors to keep track of their time, whether they think they want to charge or not. If they keep track of it along the way, it'll be really easy to claim a fee later. What's that fee? An hourly rate times the number of hours that they spent doing work, and it might again depend on whether they're spending time going through Mom's Old Magazines or whether they're meeting with the accountant to prepare tax returns. Different levels of work can be subject to different reasonable hourly rates. Court sets what's reasonable if anybody fights about it, and so it really depends. I've seen hourly rates from $15 an hour being charged, being told that was too much for some of the work, all the way up to $150 an hour being totally reasonable. It really, every situation, every estate, every executor, and the work they're doing is going to be different.
Okay. What's the difference between a revocable living trust and a will? And does one cancel the other if you have both? And is one better than the other?
There's as many different answers to those one better than the other as there are attorneys out there. I think that in Washington, with Washington assets, a will is better. And can a revocable trust cancel out a will or a will cancel out a trust? The reason that revocable trusts work is because instead of you owning your asset, your trust owns your asset, or your trustee owns your asset, and there's a succession of trustees set up in that revocable trust. And so the trusteeship doesn't die even when you die. That only applies to assets that are properly deeded or transferred with banks or financial institutions into your trust. And so if your trust owns it, the will does not control. If the trust doesn't own it, the will could cancel out the intentions of a later dated trust if the assets aren't in the trust.
Okay. Can you speak to, are there any issues to leaving money to people or universities or charitable organizations out of state, out of Washington State?
Nope. Every state, you can leave money to people in any country. Different countries, different states may have inheritance taxes. Washington does not have an inheritance tax. I'm most familiar with a few European countries that basically say, oh, you just inherited $30,000? We want our piece of that because the limit was $15,000. That can happen with some states. I think there's still 3 or 5 states that impose an inheritance tax. even when you're inheriting assets from out of state. But as far as Washington is concerned, or the difficulty of administering the estate here, it's quite easy, and we regularly send assets to beneficiaries, charitable or otherwise, in all 50 states.
I think, go ahead.
So I have a question that kind of piggybacks on the question this gentleman asked. If you have a couple and they each have separate wills, but they're very similar, and one has been deceased for a while, because we're in a community property state, does that intention of that person and that portion of the estate of that person become invalid because the other person now holds all of the assets and the estate?
Pretty much, that's sort of what I'm saying. When you give money to someone at your death, whether it's a charity or whether it's your spouse, if you've given it to them and you haven't placed any restrictions on it, there's no strings attached, it's not in a trust, it's not a life estate. Once you've given it to them, they can do whatever they want with it. And the only way that a couple can be obligated to follow the wishes of a prior will of a now deceased spouse is if there was actually a contract or a premarital agreement or something that they both signed that said, this is a contract, we will both agree to always include these provisions in either of our wills. Those can exist, those are more complicated arrangements, and without that, once you've given it to them, it's theirs and they can do whatever they want with it.
So the remaining person doesn't have to do a new will to make it different than the intentions of the other person, right?
Depending on what their old will says, if their old will included the other person's beneficiaries, they would need to make a new will. If their old will didn't include the other person's beneficiaries, then they can leave it the way it is. I try and make sure that most of the couples that I work with have a plan that looks pretty much the same so that it doesn't, if they die within a relatively short period of time, that both beneficiaries are included sort of regardless of who was the survivor, but make it very clear to them that the survivor can always change their will.
So last question, and then we're gonna address one of the handouts that you have at your table. If you don't already have an attorney, and you don't know any attorneys, how do you recommend one go about finding an attorney to work with on your will?
Ask your neighbors, ask your friends, ask people at church, ask any of these wonderful charities who are here today. They know people, and if you're here today, you know me now. So that said, I don't know how people find attorneys. I ask when clients come into my office, how did you find us? Is there somebody we can thank for your business? And more often than not, I get answers like, well, they saw us in the church bulletin, or, oh, we looked at your website, or we Googled and we found West Seattle and you're an attorney who does wills. And while that's lovely, I can't imagine going online and Googling attorney and picking an attorney that way. Nevertheless, folks oftentimes do that. A personal recommendation from a friend or a neighbor or somebody that you trust is always a good bet.
The senior center often has access.
Exactly.
So Heather, thank you so much. Yeah, I was just going to talk about so one of the handouts that you have in front of you, one side it says gifts by will, and the other side refers to beneficiary designations. And Heather already did a great job addressing that before lunch, but we just wanted to provide this to you as a resource that you can work with your advisors. And you know, we're here today because we care about the sponsoring organizations that have invited us, and I would venture to guess that these organizations are deeply aligned with our values and what brings meaning to our lives. And so thinking about making a charitable gift in your estate plan can be a meaningful and a really smart way, as in a tax efficient way, to distribute your resources and to accomplish really important things for the charities that you support. So let me just say that on the side that says gifts by will, sample bequest provisions, you know, as Heather described, these are some different ways that you can make charitable gifts in your will. And one way is to just make an unrestricted gift. And as she said, you know, you can do that in a dollar amount, or you can do it as a percentage of your estate. And you can also designate a specified purpose of your charitable gift in your will. So I give to whichever, if I gave to Fauntleroy Church, I would say for the benefit of the fund for the future, for example. So that you can designate a specified purpose. You can also make gifts of personal or real property, charitable gifts of personal or real property through your will. And so this is just some sample language that you can use in working with your advisors. And the other side of the sheet are some good things to think about the beneficiary designations. And Heather's talked about that a number of times, and it really is an important opportunity for you to be thinking about it's a simple and it's an affordable way to make a gift. You can designate a charitable organization as a beneficiary of your retirement, your investment or bank account, or your life insurance policy. And it's also possible, on these beneficiary forms, you can make a charity a percentage beneficiary. It doesn't have to be the sole beneficiary, right? There are a number of different ways to work through it, but I really appreciated your comment about how it's important to share your beneficiary forms with your attorney. So thank you for saying that. So some of the benefits that I just want to highlight, you can make a charitable organization a beneficiary of your retirement account and can still continue to use that retirement account. It doesn't stop you from accessing funds from that account. And the other important point that Heather made, but I just want to stress that when gifts come from your retirement account to a charitable organization, there's no tax. The charitable organization does not have to pay tax on that. But for your heirs, there are times when gifts from your retirement account, they will have to pay, or they will have to treat that as ordinary income, and they have to pay taxes on that. So there are things to consider about if you're charitably inclined and making charitable gifts as part of your estate plan. There are more efficient ways to give to charity and other efficient ways to give to your heirs. Do you want to say anything more to that? Or?
Yeah, I think that that's a very important point, and I'm always working with clients who are charitably inclined to make sure that we get the maximum amount of dollars or of the assets of their estate to the beneficiaries, and make sure that we're keeping the least amount going to taxes, the least amount going to the IRS or going in administrative expenses because we didn't set it up right.
I'm sorry I missed the first part of your presentation, so if you've answered this, I apologize. But should you, at the time that you make the provision, let the charitable institution know that you're doing this? Because I was the executor of an estate, and I called them up and I made somebody's day by telling them that they received this money, and they didn't know about it, so.
I would say they are always happy to hear about it. If they hear about it from you while you're alive, that's lovely, and they'll often want to come up with ways to thank you. If they hear about it from your executor or the attorney afterwards, they'll want to come up with ways to thank you and your executor and the attorney afterwards. They're always appreciative of knowing when those gifts are coming because it can help them plan.
So you should do it early.
It's a little tricky notifying them early when what you're giving them is a percentage of your estate or a percentage or the remainder of your retirement account, and you don't know what that will be, or when they're a contingent beneficiary if one of your other beneficiaries doesn't survive because it might never come to pass. But it's always nice to let them know when you've included them in your plan. So.
And I'll put my hat on as what I do in my life is at Seattle University. It's really, really helpful when people let us know, because we can work together to make sure that your intentions for what you want to support are exactly what we can make happen. So it's ensuring the wishes of the donors is really an important step. And the other step I would just add to this is that I ask our donors to share with us the name of the retirement account and their retirement account number. Because there are instances where the charitable organization may have to contact the retirement account. And if we don't have that information, then we can't insure and do the follow-up that sometimes is necessary. So it's two things. Yeah.
Along that line, on the wording, where where it suggests the different options. I don't see anything in here if you're giving to a charity where it asks for the tax ID number. And I have found that to be helpful with the estates that I've been working with, that if they say, you know, XYZ charity, a Washington nonprofit corporation headquartered in, or give the address, and then whose tax ID number is such and such.
Great.
Is there a reason that that hasn't been included there?
I provided that information, and that's what we provide, so that came from me, but you're correct that it's good to have the tax ID number. So you can
I
use
try
that.
and include it every time I'm
Yeah.
including a charity in someone's will, when I can find it readily on their website and don't have to go to some of the other organizations where it might be available, or go look up their publicly available tax returns in order to find that number. It's always nicer, but it's not required to be in there in order for the gift to be valid.
So Ellen, can I just say that if you're looking at the Gifts by Will page, where you would do that, right, Heather, is you would just say, I give to blank.
Right. After you name the organization, there would be further information saying what their address is, you know, what either their headquarters address or the local office address that you want to donate to, and what the tax ID number is. It's the same way I might use the house tax parcel number when I'm giving a house in a will. The more identifying information you can give to be particular and not have some confusion over whether you meant the American Cancer Association or the American Cancer Society, because they're both out there, the better.
Nancy, did you have something?
Yeah, just a quick thing, I wanted to piggyback on what you said, Westside Baby, because it's fun to get that call that says, oh, by the way, we left you this money, but we've missed out on the chance to really have that relationship with you at the time, or the person that you're the executive for, while they're alive, because that's when it's fun for us. It's great to get the check later, but what if we could have, you know, shown you the impact of what your gift is going to give over the time when you were alive. So where this says, you know, leave something more than memories, I think there's something really telling to say, also be involved in something more than just the memories, because you will get something from it while you're still alive. So I would love it if people would tell folks early on, because I think all of the nonprofits here would like to have a relationship with the people that are choosing to honor us later.
Well, that's a great way to close. And Clay, did you have one more?
I just want to add one last thing to that, and that is that some people who make such plans and notify the charity also can be a service to everybody by being allowed to be interviewed about that and used as an example about somebody giving to a charity in this way, so that other people can look at them and say, I can do that too.
That's a wonderful point. That's a wonderful point. So I know we're at time here, and I just can't stop. We're going to thank Heather in a minute, but I just really have to thank Maria. This was Maria's idea to put this all together. So thank you very, very much.
And Heather's only remuneration today are these beautiful flowers. And I'm going to make her toot her own horn for a second, because what she hasn't done yet is tell you how you can reach her. My husband and I had our wills done by Heather. I can tell you personally that she's amazing and thought of things that we would never have thought of that I'm sure are going to really be helpful to us in the future. So Heather, will you please give everybody your phone number and your email address, please?
Sure, well, I'll start with the website because it's the easiest one. It's westseattlelaw.com, and you don't have to know how to spell my last name in order to find us. And our phone number is 206-938-5500. And as we talked about, I do all the things, estate planning and elder law and wills and trusts and probate. My partner who is with us here today also does real estate law. So when folks want to gift their house to the charity while they're still alive, she can help with that. When they want to do inter-family transactions with real estate, she helps with that as well, and a number of other real estate related matters. So to know that we're here for more things than just wills and trusts, and are happy to help any of you with questions that you might have on these issues.
Would you give your
email again?
The email is heatherd@westseattlelaw.com.
Heather, thank you so much. And then we would be remiss if we didn't thank the people who fed you today, the wonderful organizations who helped sponsor this event, starting with the YMCA. Yay for the Y. Yay for Conroy Church. Yay for Westside thank you. Southwest Seattle Historical Society, thank you. Yay for the penny. And Southwest Youth and Family Services, thank you so much.